undergraduate degree from Caltech. His law degree is from USC. That's the University of Southern California, not the University of South Carolina. I made that mistake because I have a niece at the other USC. Yep. His LLM from Columbia, PhD from the University of California at Irvine in Criminology, Law, and Society. Professor Gruner is a co-author of 2 case books and an update author on a treatise for white-collar crime. 2 of those. He's the former director for the Center for Intellectual Property here at John Marshall, and he's the founder of the Summer China program. So without further ado, please put your hands together for Professor Gruner.
All right. Well, it's my great pleasure to be back at John Marshall, and I want to say an initial thanks to Darrell Lim, to Bill McGrath, and to the staff at the IP Center, as well as the events staff for making this possible. I have had the great pleasure recently to be part of this continuingly strong IP program. I was here as recently as November to be part of the excellent IP conference, and I look forward to continuing ties here. Today I'm going to talk about 3 seemingly simple topics: imagination, invention, and patent incentives. But I'm going to hope to convince you that these are not so simple, number 1. Number 2, that they are linked in concept and in execution, and that particularly we can influence through patent law and patent incentives how invention processes proceed and how invention failures are handled in ways that minimize the impact of these failures on our society and on the patent system. By imagination, I should start out with an initial definition so you know the basic setting that we're talking about. Imagination involves, in its most general form, the creation of a mental image of an event or circumstance, basically a constructed reality. Now, what does that have to do with the world of invention and patent law? Well, invention usually involves a specific and special kind of imagination, that being imagining a design for an artifact, either an artificial item or a procedure, that achieves some functionality. Usually the functionality is to solve a problem that some user set is interested in, but the design of the invention is an act of imagination. So what we learn about imagination also helps us learn about invention processes. And as we'll see today, my theme is that some of what we know about imagination problems and failures tells us a lot about where inventions are also going to fail. And once we understand where the failure modes are for invention, we can do something about them through patent law scope and particularly the impacts of patent law incentives. So where am I going today? The first major thought is for you to remember that invention is an imagination process. There's a false but commonly heard slogan that form follows function in invention. That's false because the reality is that invention and form of inventions follow failure. Usually an invention is to fix or improve upon some circumstances of failure and problem in an activity that a user might have. So for example, when we're designing an improved pencil, one might develop something along the line of the mechanical pencil because it avoids the sharpening process, it advances the lead conveniently, it solves the problem of updating your, having a pencil lead available when you need it. So invention is a process of imagining a solution to people's problems, and we'll get into that a little bit more further on in the presentation. The advance that we have available to us today, and the real trigger for the talk that I'm giving, is that we now understand through psychology research a lot of insights about why imagination fails. We understand that there are specific systematic errors that parties engaging in imagination commonly encounter, commonly stumble upon, and that leads to certain types of errors in projecting not only how events will transpire in the future, imagining how future events will be carried out, but also imagining how people will react to those events. So in an imagination of invention process, where we're trying to imagine a solution that will make people happier with some process, happier with a task of writing, if you will, in the pencil context, we get it wrong a lot. We make errors in estimating how the writing process may proceed under a new pencil design, and we often misestimate how users of a new design will feel about that design, whether they will feel that they are advantaged or not. And so what we can do, and what this talk will do, is transfer some of our learning about psychology into the world of learning about inventions. In addition, and this is where we now move into the patent law implications of this advanced learning, is that we can understand better how the current patent laws are operating in light of this psychological understanding. That's a descriptive version of how we might use our psychological research findings to better understand patent law impacts. And in addition, we can think about reshaping the patent law so they might work better in light of the errors in invention that are going to be generally prevalent. Okay, so today we're gonna explore those three themes: the nature of imagination and its failures, number one; the carryover into the world of invention of those errors, number two; and in light of those errors, the things that patent laws can do about them. All right, so imagination is a topic of importance for all of us. We engage in imagination all the time, not just in constructing something like an invention, but in just thinking about plans that we want to make for various activities. Today, when you decided to come to this presentation, you engaged probably in some imagination about what it might entail. You used information about past John Marshall presentations. You used some projection of my topic as indicated in the title of the presentation. You projected what you thought would happen here. You evaluated it against alternatives available to you, and you made a choice to come, and I am very happy that you have. But that was all, in some degree, based on imagination. You imagined what this event would be like. So we do this all the time. The problem is that we often engage in some of the errors that I'm going to describe in a minute. We think we understand how future events will transpire, and we think we understand how either we or others will react to those events, but we are systematically wrong much of the time. In the area of invention, as we transfer that thinking about imagination into the area of invention, we can see various types of inventive steps that are acts of imagination. An inventor typically will imagine a number of things in creating a new invention design. In fact, the imagination process starts even before the inventor puts together a design. The inventor, will often have to imagine features of the potential user's environment, particularly where the inventor is not an active participant in that environment. So as engineering knowledge has become more and more specialized, and one needs an advanced degree to engage in a lot of inventive efforts, those parties are not of the same training or not of the same experience as the user set towards whom the inventions are often targeted. And so, number one, the inventor is projecting their own expectations, or they're imagining what the needs and problems of the user set will be. Once they have that in some mental picture, they'll try to solve that problem. They'll try to figure out how either an existing tool can be improved to better achieve a solution, or they'll sometimes come up with a whole new tool, but that will be dropped into that problem situation and hopefully achieve a partial or complete solution. And so the functionality of the invention is part of that mental picture that the inventor comes up with. They, however, will hopefully try to estimate the usefulness of this imagined invention to the user set. And to do that, they'll have to think about the context of use. You know, will it be easy to pick this new tool up and put it to its intended use, or will use in context be its own problem? How much functionality will the invention achieve in that context of use? Again, a point of imagined functional impact. And then finally, will the users be happy with that result? If they don't find it advantageous to use that new tool, they won't use it. They won't buy it. They won't put it to applied use. And in a societal sense, that's a failed invention. It may technically have had some functionality, but it really didn't do anything that we care about. All right, so all of these things, though, are in the imagination of the inventor when they come up with a new design approach or new design detail. And so there's a lot of imagination going on in the creation of a new invention, typically. Well, okay, given that imagination is the core of invention, what do we know now about the errors that are typical in imagination projects? This is where the new research steps in. And there are findings that we are systematically wrong in 3 areas. As we try to project future events and future reactions to those events, typically our imagination will engage in undue presentism, which is a catchphrase for an unfounded presumption that tomorrow will be like today. That yes, some of tomorrow will be like today, but we presume way too much of tomorrow will be unchanged. And therefore, we construct our imagined inventions or our imagined scenarios for the future with too much of a sense of unchanging circumstances and features. A second area of systematic error is the possibility of excessive realism. We imagine features of events or inventions, but we lose track of when we have made something up, where a feature is fictitious or extended or changed in ways that are possibly going to change. And so we imagine as a continuing reality features that are in fact fictitiously constructed. And then once we engage in that sort of false extension of reality, we don't challenge it. We think that, oh, that's something I know is true or happening or has happened. And the lack of a distinct boundary line of, gee, I just engaged in something that is a fictitious construct does not occur, and therefore we don't analyze our imagined images sufficiently. The third area that we tend to make mistakes is that we misestimate how either we or others will react to future events. We misestimate because in part, we assume our current values are the values of interest. That may not be true even for our own selves. Our own values may change. Our own values may change with the context of use of something. In addition, where an inventor is trying to project and take into account the values of other users, people unlike the inventor, there are several reasons they may misestimate those values. They may misestimate them because they did not understand them in the first place, or they may misestimate them because the inventor doesn't understand how the user's values are changing over time, over the period in which the invention might have been used. So these are systematic errors that we'll see crop up in invention, and they are the types of errors we hope we can counteract with the patent system. All right, well, to unpack each of those 3 errors a little bit, why do we tend to engage in excessive presentism? Why do we assume that the future will be like the present? Part of this is that once we experience an event, it sticks in our minds. We have a sense that those events are immutable, and that we just sort of naturally bring them back into play when we imagine things. We tend to rely on memories unconsciously. Even if we're working on a new design feature, we will remember our experiences with the unaltered version. So for example, if we were working on a new pencil design, we would be remembering and injecting into our thinking a whole bunch of past experiences with pencils without even realizing to what extent we were relying on a particular memory or a particular past feature. The past carries forward in memories almost automatically. Sometimes the past carries forward because we consciously want to focus on the new features of an invention or design. And maybe that's an efficient choice of where to put our time. We want to pay particular attention to the parts that we're interested in changing, and we just kind of casually assume that everything else is as it was. We may just be lazy. Sometimes we're in a hurry and we just don't want to unpack and reanalyze how much of the past will be subject to change. And then finally, some of this is just a necessity driven by information overload. Our brain works this way because it could not reanalyze every feature of a situation that we're taking into account. It has to make some approximations. And the approximation it makes is, well, yesterday's reality is tomorrow's reality, and in many respects. But we tend to accept that automatic extension of past reality without much critical reanalysis, and often it's wrong. We also accept imagined features of designs without enough self-criticism, and there are several reasons for this. One is that our imaginations are very good. It is sometimes hard to remember, particularly once you've completed an imagined image of something, to remember where your newly constructed fictitious set of features pick up and the actual experienced features leave off. Parties in the law that deal with eyewitness testimony deal with this problem all the time. People will say, walk up a set of stairs, later be asked about that passage through the set of stairs and swear that there were flowers off to the side. Well, there really were no flowers. There were flowers there 6 months before, but they've melded the reality with some memory or fictitious creation, and they will stick by that account later. That's in the circumstance in which sometimes eyewitness testimony is truly believed by the person giving it, but inaccurate. And it's the same in the world of imagination generally. We tend to accept some of our memories and some of our imagined created circumstances as real when we have made them up. We also, once we have this image in our mind, are biased towards favorable assessments of the reality. If something works well, or we think it's going to work well in our imagined design, we bias the critique to come to the result we want it to be. We want to succeed, and therefore we look at the favorable aspects of analyzing it and don't do the rest of the analysis. And in a like vein, we tend to eliminate the inconvenient details. Perhaps it was hard to make that invention or that tool. Well, we're going to deal with that later. And so the net analysis that we come to is heavily biased towards a overly optimistic sense that we have a real concrete item in hand when in fact we've embedded a lot of fictitious and often incorrectly conceived features. And why do we project future responses with present values? Well, we often, first of all, accept our own values as those of the general population. Interesting research found that if people were asked in general, what do you think makes up a good character of an individual, what features would be in a person of good character, they wrote down a list of features, and then later asked the same people, describe your character. Well, in fact, their character matched the features of a person of good character. They basically had cooked the standard in step one without really realizing that, in fact, they described themselves as they saw themselves. So we have accepted our values as controlling because we have perhaps an overly self-important impression of what the general population is like. We think everybody's like us. We also have a tendency to ignore the possibility of change in values, whether that's our values or others. And so we often make an assessment that something will be valuable, but that's on the assumption that today's values will control when the future activity comes up. We also, as with the analyses I was talking about before, tend to cook the analysis. We tend to underplay the possibility that future changes will be adverse to the values that we have now, that people will find other problems more important in the future than they do now, and therefore see less net value in an imagined invention or other circumstance. And then finally, we, in addition to the features of the thing we're constructing, the features of the context in which it's used, we assume those are unchanging when in fact they may change in ways that makes the thing we're creating less and less valuable. The final thing to remember about this trio of sources of error is that they're cumulative. A given projection of an invention or imagined image of an invention may be subject to all three types of errors. And to get it right, you need to overcome all three kinds of errors. And so the potential for at least one of these stumbling points to be present in a given inventive project is highly likely. This is most likely for the efforts to create what I've called outlier inventions, but inventions that depart materially from past inventive practices and engineering knowledge, the sorts of inventions that our patent system is most concerned about, the so-called non-obvious extension of prior technical knowledge. And so if it's hard to project a few changes from present technologies, it's especially hard to project major differences from past experience and technologies. Okay, so how does this play out in actual inventions? And so this is the sort of concrete, we know we've got three kinds of errors at stake. What does this mean in the world of invention? Well, the tendency in the area of excessive presentism will be that designs will be conservative, that the tendency will be to both design for the same problems we have in the world today and design to solve them in the same ways that we solve them today. What this means is that as much as possible, new invention designs will incorporate old features of existing tools or processes with a little adjustment in maybe one little component. And as little adjustment as possible to ensure that we can predict how the modified version will work. So in many respects, there's a drive towards conservative invention, conservative adjustment of past technology designs. And what that means is we'll get a lot of predictable, obvious new inventions. Those are great, and in fact, those are the most prevalent types of inventions in the world because many people can make them. But we don't achieve the sort of new technological leaps that we hope for, and we also, as we'll see in a minute when we talk about patent law standards, we don't create or see the creation of inventions that will qualify for patent rewards. In the area of excessive realism, the problem is that an inventor will think they have a complete design that works in some functional manner, but will tend to leave out a lot of key details. Either something won't work to complete the process or functional sequence that the inventor is counting on, or that there will be some adverse factor they've just left out of the picture because it's an inconvenient detail or something they didn't have to think about, and they won't. This results in incomplete testing, incomplete self-criticism, and ultimately invention designs that have unappreciated flaws or that operate with only partial functionality, that don't operate nearly as well as the inventor thought that they would. And then finally, the third type of error, inaccurate rationalization, tends to cause inventors to be over-optimistic about their estimates of invention value. They will see value in a design when the intended user set will not see the same value. And so there will be great enthusiasm by the inventor, but many of these will be a bust in the ultimate marketplace and in the ultimate societal measure of net utility added to our activities. And as part of that, not only will inventors overestimate their own invention's worth, they'll tend to underestimate the possibility that there are alternatives that trump their invention. So once again, they'll tend to feel that there's more net value in their own invention because they don't see that there's a competition between their invention and other solutions to the same problem. Okay, so that's the world of invention that is plagued by systematic errors and leads to a lot of failed inventions, failed in a societal sense, inventions that don't matter much to us as a society. Now, that's not to say that all efforts to invent fail. It's to say that many of them fail. In other words, this is an error-prone process, and we ought to take that into account. We ought to be appreciative that only a few of the many efforts to invent, and particularly to invent with a non-obvious type of outlier design, not many of those are going to be successful, but a few will. And so our patent system now can be brought into play. And right now, the patent system does several useful things in dealing with these types of errors that I've described. And so I'm going to take a second right now and give you a descriptive account of how the patent system works in light of these errors. Our understanding of the psychological errors gives us a richer account of the present patent system and some of its dynamics in the context of invention. And so this part of the talk will be a descriptive backward look, in other words, the patent system as it exists now. In a minute, I'll talk about a further normative account of what we might change to do better. But right now, the patent system helps to offset these psychological limitations of invention in three important ways. The most fundamental is that because the patent system and the rewards of patents attach to non-obvious extensions of prior technology, this is one of the basic patent law requirements, but to qualify for a patent and to have your patent be enforceable even if you've been given one by the patent office, you need to be able to show that a given invention is a non-obvious extension over prior technology that persons of average skill in the field would have been unlikely to have reached. They would be unlikely to project that this design approach would be successful. So the patent system attaches to the inventions that are not predictable in that sense. Well, that means that it gives special rewards to those few advances where the inventor has gone outside of the simple projections, outside of the small changes from old technology, and has in some dimension made a significant leap. Now, reasons for that significant leap, it may have been accidental, it may have been that they're specially informed, it may be that they're high risk takers. For the purposes of this talk, we don't care which of those scenarios is true. What we care about is that people either, as they develop their inventions, they go for the fences, if you will. They go for designs that are significant departures from past frameworks. Or alternatively, when they get one like that, they surely don't leave it on the table. They go for the patent that follows up on it, because we'll see in a minute that patent is the vehicle for ensuring that those rare but successful non-obvious inventions are brought to the public, are actually meaningful in our society of technology use. So the first impact of the patent system is to overcome some of the features of excessive presentism. The patent system encourages something that is not bound by the present technical understanding, but rather distinctively different in at least one component. The patent system also counteracts excessive optimism in inventive designs because it forces inventors to do two key things. One is to reduce the inventions to practice, or at least a state of knowledge that would allow them to bring it to practice, and separately to confirm the practical utility of these inventions, and essentially to show that there's not some missing part in there that is necessary to do something basically useful, that they've at least created a complete sequence of either mechanical operation or overall operation, no matter what type of invention we're talking about. This ensures that optimism, or essentially assumption that something will work when it really is untested, will tend to be minimized because the inventors have to bring the inventions to a further state of actual creation of a working model or something very close to it, and that process helps to ferret out or reveal the points at which they were making assumptions and points at which they were not testing their own mental images of how this should work. And then third feature of the patent system that somewhat offsets the mistaken utility estimates is that once a patent right attaches to a given invention, it's a strong source of encouragement to other parties, usually companies with resources, to number one, give that invention a careful scrutiny for market importance, for manufacturing ability, how much will it cost to produce in large scale. And if it appears in that analysis to be a likely candidate for success, to then bring it to the public and make it the ultimate market test. In other words, to put it before the public and decide and allow the user set to decide whether they want to pay for it, how useful it is, how popular and impactful it is. And so in two different stages of the route to market, the analysis by the potential commercializing parties and then the ultimate commercialization, the market test ensures that the user set will identify inventions that are of value or are not. They're the ultimate arbiters of success, and the way we determine whether a given invention is a success is the patent rights encourage those users to be consulted in a meaningful manner. Okay, so that's the patent system as it now exists, and that's an important story of itself. We need to overcome these possible problems with invention, and the patent system is driving some good solutions. But we can do better. And so what kind of enhancements would the psychology suggest we should make in the patent system? To better overcome systematic conservatism, in other words, a sense that tomorrow's reality of invention should be much like today's designs. The non-obvious standards could be made to more directly refer to predictability of success in designs as a measure of obviousness. In other words, to the extent that prevailing engineering understanding would predict the functionality that a new design achieves, that's simply an obvious invention that should fall outside the patent system, and give essentially a clearer definition to what is obvious and non-obvious, and make that a measure that depends directly on predictability in light of existing technology information. The consequence of that line drawing, if you will, would ensure that parties who are going in unpredictable directions, directions of functional design that would, to most practitioners in the field, be predicted either to fail or would not be predicted to have any helpful consequences, that people who are willing to be pioneers in those generally neglected directions are the parties that we want to especially incentivize, with the patent system. And by attaching our patent rewards to those difficult projects pursuing these kind of outlier designs, we should get more of the outlier designs. At the same time, the bulk of invention that is going to continue to be conservative will proceed without impact of the patent system. We won't be restricting it in any way. It'll be subject to normal competitive forces that will drive enough of that less ambitious and less non-obvious invention to go forward in the same period. In a different direction, we can better counteract the excessive optimism that tends to plague inventors' efforts by increasing the demands for complete descriptions of practical examples in patent applications, to go beyond just a reduction to practice, particularly where the inventors have already created practical examples in their own labs, to compel greater disclosure of those, to illustrate where the practical flaws or weaknesses of the invention might be. We're suspicious that the inventor has essentially selectively edited what they're going to disclose, and that it would be helpful to know the full range of information that the inventor might have about flaws and strengths of the inventions at hand. And then, in addition, if there's been any comparative testing of the invention, either against earlier designs in that same field or other products that achieve similar functional results for users, that those comparative testing results also be part of the disclosure, so that parties at least get the full advantage of the inventor's self-criticism as far as it's gone. We're suspicious it hasn't gone far enough, but we at least ought to start the further evaluations with everything that the inventor has achieved by the time of the patent application. And then finally, the correction of utility estimates. The key there again is market tests, and we want to ensure that patent scope is interpreted coextensively with the full range of commercial applications of the patented designs. This is to ensure that if you have a new invention and it has multiple markets or potential areas of consumer use, that the patent rights extend to all those consumer uses, because it's the patent rights that trigger interest on the part of potential commercializers, and it's the patent rights that will pluck these inventions out of the vast array of new designs and give them a special attention in later commercialization processes. In addition, another change that might be undertaken to encourage commercialization and ensure that a new design is not held in limbo by the issuance of a patent, which is not then carried forward into a commercialized product. The change would be to institute working requirements. Now, working requirements are controversial in the U.S. system, but essentially a requirement that a product be created and brought to market, or if that is not done, the consequence being to potentially lose the patent rights. The idea being that triggering a market test of this sort is critical, and this is one way to create further leverage on the patent holder to get the designs into the marketplace for the market reaction to become apparent. On a similar vein, and another solution that might avoid the controversy of working requirements is to increase the timing or size of maintenance fees. It could be either change. The timing, if one is required to pay a maintenance fee earlier in the life of a given patent, that would encourage the patent holder to get serious about commercialization at an earlier stage. They want to know about commercial potential before they have to make the next maintenance fee payment, and by putting those deadlines for maintenance fee payments earlier in the life of the patent, the pressure is to commercialize or give up earlier. Likewise, a larger maintenance fee early in the life of the patent forces a serious evaluation of commercial potential to a stronger degree. And so if the idea is to encourage potential commercializers to focus on patented inventions and separate the wheat from the chaff as early as possible, larger maintenance fees would have an impact along that line as well. So to conclude, invention is hard, and we now understand why it's so hard. We are systematically programmed to fail. The fact that invention requires, in most cases, a significant amount of imagination and accurate imagination of how a given new design will play out in the affairs of users. There are many reasons that those projections fail. We understand now how we're systematically programmed to fail, along the lines of the new psychological research that identifies 3 types of systematic errors. We know in particular that non-obvious departures from past paradigms are particularly hard. They're particularly prone to the types of psychological errors that we have been talking about, in part because the degree of departure from the past is necessarily larger. It's harder and harder and harder in general the further you get away from past designs, but we want people to get away from past designs in the world of patented inventions. Patent incentives can produce more of these outlier advances, these rare but very important outlier advances. And so one thing that we should keep in mind as we look at present patent laws and assess possible future changes is, are we successfully driving enough efforts to produce these rarely successful non-obvious outlier designs? And then separately, as we think about present laws and future laws, are we sufficiently ensuring that once a patent is achieved, that a market test for that patented design, meaning an attempt to commercialize, is both analyzed carefully by some interested party with the resources to follow through, and then, in many cases, that follow-through is achieved as well to bring the actual products to market in enough of a scale to let the consumers decide. So that's the world of the patent process and patent incentives as now seen through a psychology research lens. And I hope I've added to your understanding of what patents are doing now and perhaps suggested some directions that we might move in the future. I've left some time for questions, so I hope you have some questions. I'm happy to answer them.
Is your theory based on any examples?
Well, the examples are present in failed designs in a number of fields. You could find them, I think, in the efforts of inventors in pretty much any domain, but the reason you don't hear about them is that these are the advances that failed somewhere in the process. They either didn't get brought forward in a patent, or they achieved a patent, but somewhere in the commercialization process they fell by the wayside. So there are examples, but they're all in the failure bin.
Well, what about the successes? You know, the case of Smith versus Hughes 2, or Gore versus Garlock, classic cases of non-obvious by the Federal Circuit of the
Yeah.
where very tiny improvements by someone of knowledge in the field turned out to be earth-shaking in the market.
And there will be those successes. The analysis here is to the effect that there won't be many of those. There'll be a lot of attempts to get that one rare success that is both non-obvious within the patent sense of that term and a market success, meaning consumers like it in quantity and are willing to pay exceptional amounts for it. Now that is an example that apparently had commercial traction, so the only question that was left is, could you keep the patent right cloaking it? And it did work that way. So it's not that patent incentives should be concerned with, small details, big details. It's how predictable was that change to work in the way that it did work. If most people in the field would have predicted that outcome or that functional change from the earlier designs, then it should be treated as an obvious extension, patents shouldn't attach, et cetera.
Right, but that's what examiners do all the time.
We-
And the job of the inventor, the patent attorney, is to tell the examiner, why is it that this particular improvement, even though it's small, is very significant?
And I'm assuming that they get that right most of the time when they're advocating and actually convince the examiner. This is not an account of there are flaws, obviously, there are errors as examiners may issue invalid patents, although we still have challenges in litigation for the ones that slip through. This is on the other side of cases where, as perhaps the illustration you were using, the inventor has done something big or small that makes a very significant functional difference and was not an obvious type of change to most people in the field. We want those inventions, first of all, to get the special incentives of the patent system, and second of all, not to be lost when there's a design like that on paper, not to be lost without commercialization. And in that sense, the rare successes will be driven forward by the patent system, even though we know there are going to be a lot of failures. So it's a matter of changing the odds on both, if you think of this as a universe with a certain number of errors, if we increase the number of attempts overall, we're going to increase probably the number of successes. And so that's the first impact of the patent system by driving non-obvious invention attempts. And the other is when one of those successes comes up, it shouldn't just disappear without realization in widely marketed products. It should, in fact, have a commercial opportunity that attaches to it so that it gets serious attention from companies that have the commercial wherewithal to follow through. And then hopefully many of them are actually followed through on to produce products that we can access or the relevant user set can access in quantity. Other questions? Yes, Arthur.
From in inventor's perspective, earlier you talked about nowadays the invention is usually driven by highly educated, higher specific engineer, or versus someone who just work out in a garage.
Yeah.
Has the highly skilled or engineering degree minimized these errors that you talked about in imagination, or has that from doing the research or from the research,
Right.
it actually kind of just wash, it doesn't really matter?
So I think these errors of misestimating either the functionality or the user traction of user benefit of advances, those errors occur both in the little garage independent inventor environment and the big company or big university research environment. But there may be different versions of those stories. For example, in certain technology areas where only really a PhD in the field is probably going to, they've invested their life in PhD training and they're very good in their narrow domain, but, do they understand the activities of a homemaker, and is this a device that's ultimately going to be used in the home? They really don't have the full picture. And it's hard, and it will, I think, more and more often as greater specialization in science and technology increases, there will be more and more of that separation of worlds involved. There are cases where the invention comes out of the user set, and one of the classic examples is the individual who invented liquid paper, if any of you remember liquid paper. But this was a woman who had worked as a secretary at length and back in the pre-computer era of typing, and made a lot of errors, and by golly, she had to retype pages too much, and she said, yeah, there's got to be a better way to make improvements. And she figured out if you combined the world of paint with the world of typing, you could create a paint-like correction fluid. And this was a staggering success, and it was patented in its day. And so she understood the user set very well. She was the user. That kind of invention, though, arising right out of the well-informed user set, I think is rarer and rarer as we need more esoteric technologies to really inform the invention. Even in her case, though, there were aspects of that invention she was still imagining, like how easy would it be to manufacture this, market it, were there dangerous chemicals that were going to be involved. There were things that she was still projecting and may have gotten wrong in at least her initial version of the invention. Yeah.
I hear you advocating a number of different changes to the way that we perceive the patent system's incentive to innovate. What are the practical aspects of it? How would you imagine that happening? How would you change policy either in the patent office, or in some respects, I think you'd almost have to change the law?
Yeah.
In view of the fact that these laws, for example, the obviousness issue is developed over a number of different years, how would you, and it's been pretty much established, why would you want to change it now and get rid of all that law that has been developed?
Well, and some of it I wouldn't be getting rid of. Actually, let's focus on the non-obviousness part. It might be that this would fall within the grounds of a judicial clarification of what non-obviousness means, in the sense that we have this still somewhat ambiguous standard that refers to the skill of the average practitioner and what they could project. Well, how can they project it? What does it mean that they couldn't have made this invention? Well, if we resolve that as, okay, what it means is if that average practitioner set, that group of people, would probably have projected you based on standard engineering knowledge in their field, projected that if you make this change, it would have that functional alteration. That's an obvious invention. In other words, to link the existing standard, which is mostly would this be likely to be achieved by the average practitioner, to give a little more content to that. And I think that could be done judicially. Many of the other changes that I'm talking about, the changes in maintenance fees, the working requirements, that would require a legislative change. And I understand particularly working requirements are pretty controversial. But as we think about maintenance fees and whether they're working the way we want them, this might be a way to proceed. And the truth is that maintenance fees are already causing patent owners to make filtering choices over the life of the maintenance fees. In other words, by the third maintenance fee, I think it's now less than half of the patents survive. More than half are allowed to lapse. So these are patent holders originally, I assume, thinking they had something of commercial viability, otherwise they wouldn't have spent the money to get the patent. But now, having changed their mind, and they've had maybe 12 years to try it and make an attempt or analyze it, and either circumstances have changed, the market changed in a way that they hadn't anticipated, or they got it wrong from the get-go, and they've given up. So there's still a lot of uncertainty there that if we're going to have that uncertainty, maybe we got to have a maintenance fee scheme that drives them to make the analyses earlier. And if they're going to give up earlier. So that's another way to think of this, too. I had an interesting conversation at lunch today, another paper perhaps to be written. If, for example, at the time of patent issuance, you're thinking about either, if you're a patent holder, what lines of commercialization might we want to spin off of this now patented advance, or if you're a potential licensee and thinking, well, do we want to license that? There's a lot of uncertainty about the future. And you're engaging in yet another imagination exercise. You're imagining, will this advance be able to be parlayed into a commercially successful set of products or practices? And you're going to get that wrong a lot. And so, number one, if you're the company that might actually commercialize, you might want to engage in a lot of small-scale product testing, because you got to accept that many of those will result in a finding that this wasn't all that valuable in the first place. And so it militates towards small-scale attempts to manufacture, small-scale marketing efforts to get a lot of the actual consumer feedback with product in hand as early as possible, because a lot of those products are going to fall out of the system as failures. The other side of that, if you think about the licensing version of that story, is you're going to license a lot of technologies if they're brand new and there's no track record. You're going to license a lot that are not going to pan out, which may say something about who bears the upfront fee risk, right? If you're a licensee and you pay the upfront fee and it doesn't pan out, you're the loser. On the other hand, if the licensor gives a license without an upfront fee and it doesn't pan out, they've basically withheld any other attempt to license. If it's an exclusive license, they've lost an opportunity probably. And so that decision both to license and under what terms to license, particularly how much of the fees will be a flat fee up front versus fees that depend on the success of commercialization, might be worth rethinking in light of what we now know about where our errors of projection are likely to lie. It's another instance where we're trying to imagine the future, and therefore we're back in this world where there are systematic errors. Other questions? Well, let me say it's been a great pleasure to be back with you and think through some of these fundamental issues from a different perspective. It is hopefully an account that adds two things to our knowledge of the patent system. One is to start thinking about the degree to which the invention process that we care about is in the world of imagination, and that given that, we can start to look for insights and sources of information and critique that are critiques of imagination, because those are also now critiques of invention. The other is that the world of imagination is a hotbed of analysis in the psychology research. In all likelihood, we're going to learn more about invention and when it succeeds and fails. And so I urge you to keep paying attention to the world of the psychology of imagination, because that is the psychology of invention, and by relationship, the psychology of patent law. Thanks very much for being here, and I appreciate your having been with us today, and I'm told that there's a reception right outside, so if you have more questions, I'll be happy to answer them there. Thank you very much for being here.